welcome. We're privileged today to have Professor Scott Gerber as a guest, a professor of law at the Ohio Northern University. Is that what it is?
Yes.
And associated scholar at Brown University's Political Theory Project to talk about the Supreme Court's latest abortion case, Dobbs versus Jackson's Women's Health Organization. He wrote an article that came out before the oral arguments on November 30th in the Daily Caller. The Supreme Court's latest abortion case could have major consequences for a long-standing legal principle. And I'm going to, spoiler alert, the legal principle is stare decisis. And it was a very interesting argument from Professor Gerber, which pointed out the important role of Justice Clarence Thomas in this issue. Before we get started, I just want to say I've been listening, not to the full thing, but to over an hour of the oral arguments, which are available online. And I'll probably put a link underneath for people to do it. And they were very interesting because I had thought Justice Thomas never spoke, but Justice Thomas, I think, started out asking the first questions, and then he asked many more questions, and he seemed very active. So that was the biggest surprise to me in the whole thing. And Professor Gerber, in addition to everything else, is an expert on the jurisprudence of Justice Clarence Thomas and wrote, as far as I know, the only book about it. And I interviewed him about that last time. So you can find that on this YouTube channel. And I want to thank you for coming back to me to talk about this. And please, what do you have to say about, first of all, let's start with Clarence Thomas's role and then go to the stare decisis.
Yeah. Well, he used to not ask questions because he felt his colleagues asked too many questions. And he thought the lawyers, since they only each had generally 30 minutes, deserved their 30 minutes. And during COVID, however, last year, they did the oral arguments by telephone. And so Chief Justice Roberts just went by order of seniority, and Justice Thomas is the most senior of the associate justice. So the Chief Justice asked Justice Thomas if he had any questions, and so he did. And so that's how it went last year. And then this year, the Chief Justice, even though they're back in the courtroom, carried over that practice. And so what he does, he just goes down the line. So he asked Justice Thomas, he started with Justice Thomas, do you have any questions? And he did, so he asked them. It's as simple as that.
Well, thank you. It sounds like there's a new precedent for procedure that's been established that probably will continue.
Yeah.
But that's very interesting in terms of legal news that we can say you broke here on this show. Why don't you go on and talk a little bit about the importance of this case, what it means in terms of Roe versus Wade and Casey versus Planned Parenthood and the right to an abortion, and your issues that it also has to do with, or your analysis of the issues, right to life versus right to liberty. And my own question we talked about before this recording started, what about the right to the pursuit of happiness, all from the Declaration of Independence?
Yeah, okay. Well, the case is important because the petitioner, the state of Mississippi, has specifically asked the court to overturn Roe v. Wade and Planned Parenthood versus Casey. So that's a pretty big deal. When they originally filed their cert petition requesting the Supreme Court to take the appeal, they didn't ask that. They mentioned it in a footnote, but they didn't ask it. But now they're going head on. And if you do listen to the oral arguments, you'll hear the Solicitor General of Mississippi. He kept this argument 5 minutes or about, which is really short. And he just flat out said that Roe and Casey should be overruled, and he explained why. And then he took questions for the rest of the period. So it's important for that reason. And of course, the other side doesn't want Roe or Casey overruled. And so they're vigorously defending them to the Supreme Court of the United States. And what I pointed out in my piece that you mentioned, I said a couple of things. One, I found it curious that both sides are invoking stare decisis to justify their positions, and that's not possible. It justifies one position or the other. It can't justify both. And the other point was at the very end, I talk about, as you pointed out, the right to life and the right to liberty. And those are competing here because and so what I end up concluding is the court actually can't decide the case properly until it's decided when life begins, and they constantly duck that question. And there was some discussion of it during the oral arguments, but I guarantee you they're not going to answer it. And so, but my point was, if the fetus or the unborn child is alive, then there cannot be a right to abortion because the fundamental law of nature is the preservation of life. But if the fetus or unborn child is not alive, then there has to be a right to an abortion because a woman has fundamental liberty interests in directing the course of her life, including the childbearing decision. So there's competing fundamental interests here, and that's why it's such a difficult case. And finally, on the pursuit of happiness, yeah, that's the third thing that Jefferson explicitly says that we're entitled to. But I didn't focus on that because I view it more as the first. But I know before we talked, you had something to say about that. I'm not sure if I agree with it. Some people, not everyone gets pregnant just because they're, having fun and stuff like that. Sometimes it just happens. Part of a relationship, a marriage or whatever, and they just aren't ready to have a child. And so it's not always a frivolous decision, is my point. So yeah, this is a tough one. When I wrote my first book, this was the one that I couldn't answer for the reasons that I said before. I don't know when life begins. I'm not a scientist or a philosopher in that spirit. So I said, until I just repeated what I said in the piece recently, what I said, whatever it was, 25 years ago in my first book.
Well, thank you. Could we talk a little bit more about Justice Thomas's role in this whole issue? Because I think he seems to be central to what's going on right now somehow.
Yeah, he's important in at least two ways. One is, as I said, and I think it was a radio interview the day after the thing or the day of it, he articulated theory of stare decisis a year or two ago. And I think it was the Gamble case, where he said that the common law notion of stare decisis doesn't apply when you're interpreting the text of the US Constitution. Stare decisis, he points out, is a common law doctrine, which means in common law is essentially judge-made law. So there's just a series of precedent in an area of law, personal injury law or property law or contract law or whatever it might be, that a judge makes a decision about, and then later judges just apply it and refine it and advance it. But they're not applying the text of any statute or the text of any constitution. And so what Justice Thomas said in that case a couple of years ago is that, listen, what Supreme Court justices primarily do is interpret federal texts, federal statutes, the US Constitution, and treaties. And so those are written texts. And so his argument is that the text itself trumps a prior judge's interpretation of the text. So if he thinks the text says there is no right to an abortion, it doesn't matter if in Roe and Casey they said that there is. So that's essentially his thing. And then on the more substantive thing, he has already said more than once that there is no right to abortion guaranteed in the Constitution. And so he's literally already in the past called for Roe and Casey to be reversed.
Well, that's very interesting. And I think we'll have to stay tuned because I just had no idea he was so prominent in this issue. And it just seems like it's sort of in the footsteps of Thurgood Marshall and Brown versus Board of Education or something like that. I mean, he could become the lightning rod, but at the same time, abortion is an issue which, the most, shall we say, sensitive sectors of society say, disproportionately affects African Americans. And I've seen a lot of literature that it was, designed by Margaret Sanger and the eugenicists to reduce undesirable populations. So I wonder if underlying that is there's some sense that abortion is an issue that actually harms the African American community and maybe even eliminates Black lives. The other things I want to talk to you, I was listening to the arguments on the other side. They talked about the undue burden and compelling state interests. And I wonder if you could talk about that. Oh, and then of course the right to privacy. Those were three on the other side. And I wonder if you could talk a little bit about that, because, if the fetus is alive and a human being, wouldn't that be an undue burden, abortion on the baby by it not being able to be born? I mean, I think there was a case where somebody actually sued for the right to have been aborted that was just decided in the favor of the litigant who said they should have been aborted. This just came out. It's like an unbelievable decision, but because she could have killed herself anytime prior if she was serious about that, although that may be criminal too. But so the undue burden argument is one that I saw referred to, and it doesn't seem to be as clear cut as I would, as an outsider and as a male, as a non-lawyer. And then the compelling state interest, likewise, couldn't one say we've had an experiment since Roe versus Wade, and we've seen many of the slippery slope arguments about what permitting abortion would do to society come true, where now, we've had societal crisis and the roles of men and women. No one knows what sex anyone is anymore. Women are having their breasts removed and their sexual organs removed and transitioning to another sex. And, you can't say he or she, and people are denying biology entirely. And if perhaps there would be a compelling state interest going back to the status quo ante for the sake of having an orderly society that isn't going to collapse. So I'm just throwing that out there. And then the right to privacy, that's another one that was sort of interesting to me. Because I'm a man, I don't know if I've had any illegitimate children or not. Nobody's ever told me. But if I did, 50% of the baby's chromosomes would be mine. So I have no right to know, in other words, how did that come about? That it's only the woman who has the right to privacy in this case, and that no one else is allowed to know. So, I mean, these are all big issues, and you can talk as much or as little as you like, but my understanding, those are the arguments on the other side.
Okay, yeah, you've said a lot there. On the undue burden, that's simply the test that was articulated in the Casey case in 1992 that replaced the trimester framework of abortion in 1993. And what an undue burden is, it's a substantial obstacle in the way of a woman's access to an abortion. And so undue burden is a vague concept, and the court defines it with an equally vague concept of substantial obstacles. So I never find tests like that are that vague very helpful, but nevertheless, that's the test. And in terms of the compelling state interest, that would apply if it's a fundamental right. And so in Roe, abortion was a fundamental right. And the only way the court could regulate or ban it would be if there's a compelling state interest. And the way the state went about doing it was the least restrictive way to do it. In Casey, though, the court lowered the status of the abortion right. So it's actually, believe it or not, no longer a fundamental right. It is a constitutional right, but it's not a fundamental right. So for example, to make an analogy, free speech, the right to engage in political expression, to criticize President Biden or before him, President Trump, that's a fundamental right. But the right to advertise, if you're selling something, if I'm selling books or something like that, that's not a fundamental right. It is a constitutional right. but the government has more ability to regulate a non-fundamental right than they do a fundamental right. So one of the important lessons of Casey was that even though they didn't overrule Roe, they did change abortion from a fundamental right to a non-fundamental constitutional right. So there's that. And on the privacy thing, the way I heard the argument on that was Justice Thomas was simply trying to get the lawyers to tell him if they felt the abortion right was grounded in privacy or autonomy. In Roe, they grounded it in privacy, which was from the Griswold versus Connecticut case in the mid-1960s. The jurisprudence, however, has transitioned in Casey and subsequently to autonomy, which is a liberty interest. And they're of course related, because when you were describing privacy, that's the common sense conception of privacy, you know, the right to keep information private. And there is that type of privacy. There's more than one type of privacy. But what the court has later decided in Casey and later was that the privacy concept that Roe was dealing with was really autonomy. And so, but now the right is grounded in autonomy, liberty, the woman's right to make decisions about her body and childbearing. That's what it is.
And I wonder, let's talk about autonomy a little bit. Especially now we're in the context of this pandemic, where we see a huge amount of state power used to restrict the autonomy of the unvaccinated, or the vaccinated need to show proof of vaccination, or wearing a mask, or not wearing a mask, or using ivermectin, or not using ivermectin. So there are all sorts of limits, which I would assume also affect the right to life, if the debate is accurate. In what sense is the autonomy correct from a scientific perspective if the fetus is 50% somebody else's genetic component?
Yeah, they address that in Casey. And when we talk about the case in class with my students, that's always an interesting discussion for the reason that you put on the table. The one provision of the Pennsylvania law at issue in Casey that the court invalidated was the spousal notification requirement. And then the law, the Pennsylvania law said you had to notify the spouse or the father before you got the abortion, and the court invalidated that. And they gave reasons for it. Maybe the father would be mad and engage in domestic violence, things like that. But the counter to that is what you said. If there's no proof that the father is that kind of violent person, it matters to him, and I ask my students, and in law school, you have students that are fathers, not all of them, obviously, but some of them, young fathers. And so most of them say that they'd like to participate in that discussion with their wife about whether to terminate the pregnancy. They all say that at the end of the day, if they disagree, she gets to make the choice, but they'd like to participate in the discussion. But in Casey, the Supreme Court cut that off. So that's what I have to say about that.
And what about the concept of equal protection, though? I mean, it seems to me there you have a clearly sexist interpretation of the law saying the mother has the right and the father doesn't have the right.
No, I agree. I'm not saying I agree with what the court did there. Obviously, if the mother or the pregnant woman can demonstrate that if the father finds out, he'll beat her up or something, then don't let him find out. But if there's no evidence of that, and if it's a loving relationship and all of that, I personally think the father should have input in it. But I also think at the end of the day, When it's a tie vote, someone's got to have the tiebreaker, and it should be the woman because she's carrying the kid.
Okay, let's go on from that, because you said carrying the kid. The other issue that Justice Thomas and others mentioned was viability, and I think it's in your article, When Does Life Begin? And that seems to have been sort of an arbitrary thing, because what about potentiality? You know, in other words, if you carry a baby to term, it's more than likely to live. The other thing that makes this issue so fraught is, of course, you never know. I'm Jewish. You don't name a baby till 8 days after birth. The reason is because there was a lot of disease and problem pregnancies, and children died, in infancy and didn't have a chance to grow up. So you want to be sure the kid would live. Other societies practice infanticide through exposure, and we have the former governor of Virginia who advocated a form of afterbirth abortion. I just read a book by a rabbi at the university. He was at the University of Washington. He had a disabled child. He was at the Chabad, and he went into the University of Washington. The child was severely disabled, and the doctors all wanted the child to be allowed to die. And he, being Orthodox Jewish, wanted to save the life of his severely disabled child, who he knew would be disabled. And they said, well, your son won't have a good quality of life. And he said, well, in our religion, we don't care about quality of life. The important thing being alive versus being dead. And he had to have a huge struggle and take the baby to another hospital. And it was a very harrowing story of being against a medical establishment that essentially wanted to kill his baby, even though it was his religious tradition to preserve life. So these issues of life and viability, and then of course we have people going, you should practice euthanasia, or end of life decisions and assisted suicide, and depressed people can go in and get drugs. So talk a little bit about that. This issue of life is sort of socially defined sometimes,
Yeah, as I mentioned before, I say at the end of the piece, and I've said before, that the court can't properly decide an abortion case until it is decided. And I say is decided. I didn't say until the court decides. Until it is decided by someone that the court listens to when life begins. I'm Catholic, and so as you know, the Catholic Church opposes abortion at the moment of conception, but because of the establishment clause prohibition in the First Amendment, you can't define life in a religious way. And Alito made that clear, and not one single person on the court or none of the three lawyers even suggested that life should be defined by appealing to some specific religious perspective. So you have to look at the science, or you look at philosophy, or you look at whatever else there is that deals with this. And that's not what I do for a living. I'm not a medical doctor, so I don't know. I'm not a philosopher of that style, so I don't know. But that's why it's such a difficult case. I mean, in terms of viability, I think it was Justice Alito that did correctly point out that viability changes as the medical science improves. And O'Connor said that long ago when she criticized the trimester framework. And she was the one that got rid of that and got undue burden in there because the science was changing. And so I think Chief Justice Roberts, he was kind of hinting at that also when he said, well, what's wrong with 15 weeks, which is what Mississippi says? Why does it have to be 24? And then the state was also pointing out that, fetuses feel pain much earlier than 22 or 24 weeks. And of course, then the lawyer for the women's health group gets up and disputes that. But the point is that people disagree about what the science is. People disagree about what the philosophy is. People disagree about what the religious answer is all of that. That's why it's so complicated.
All right. Well, let's talk about something a little less esoteric, which is your prediction at the end. Your analysis held, and I've seen this elsewhere, the court will have to decide one way or the other, should Roe versus Wade be overturned or upheld? Now, others, Professor Jacobson on legal insurrection said, no, Justice Roberts can come up with a compromise where they say, okay, you can have 15 weeks in Mississippi, but other than that, Roe versus Wade stands. So could you talk a little bit about the predictions?
Yeah, and in the written piece, I didn't make a prediction. I made the prediction, I think it was on TV.
Oh, okay.
And so, but nevertheless, I made a prediction. There's no doubt in my mind that Thomas is going to say, get rid of Roe and Casey. No doubt in my mind that Alito is going to say it. I'm pretty sure Gorsuch is going to say it. It sounds to me, listening to the argument, sometimes they vote and write differently than what you hear in the argument. It sounds to me, just based on the argument, that Kavanaugh is going to vote to get rid of Roe and Casey. And so the wild card here is going to be Barrett. And just the way she was thinking about it during an argument suggests to me that she might vote to get rid of it. She knows that she has that seat to do that. She knows that. Doesn't mean she has to care that's why she has it, but she knows that's why she got it. And she's Catholic and deeply committed to it. And so I know personally that she opposes it. She's even signed letters as a law professor condemning Roe and Casey. But that said, it is such a major thing to do. She is a woman, and I think that would, it would be quite unsettling if she cast the fifth vote to overturn the most important precedent for the women's rights movement. That would be quite a legacy to leave. But on the sixth conservative, Roberts, I think he's going to, just try to uphold the Mississippi law and just continue to make it more difficult to get an abortion without overruling Casey and Roe. And so the only uncertainty here is whether he can convince Barrett and Kavanaugh to join him in that kind of middle ground approach. And again, the middle ground is don't overrule Roe or Casey, but continue to make it more difficult for women to get an abortion by allowing more and more restrictive state laws to stand.
Okay, so I think that's a good analysis. Now, you're not a politician, but clearly this is a political issue, and many people are writing about how it will play in the 2022 election. And if the court overturned it, would it be seen that the Republicans overplayed their hand and went too far, too fast, and there'd be a backlash from Democrats who might not have voted, because who cares about Joe Biden, but we care about abortion. What do you think of that?
Yeah, I'm, even though I have a PhD in political science, I'm not a political analyst. But yeah, I think something like this, such a hot button issue, if they overturn the right to choose, I think it would mobilize the Democratic base, and help the Democrats in the election. On the flip side, if the court doesn't overrule it, I think it's going to make the right upset, and especially upset with groups like the Federalist Society, who for a couple of decades now have been providing suggestions for judicial nominees, Supreme Court nominees in particular. And if the argument would be, if you have 6 Republican nominees on the Supreme Court and you still can't reverse the case, then what good are you doing the movement? And so what I read somewhere else was that the Federalist Society would lose a lot of influence in the judicial selection process if Roe and Casey are not overruled in this case.
Well, let's talk about that, because what's interesting to me is the court, they say, is aware of election returns and reads the newspapers and blah, blah, blah. To what extent has the public not been prepared? The problem with Roe was the public wasn't on board with it when it was decided. And right now, there's no public consensus one way or another on this issue. And to what sense do we as a nation have to come to grips with what do we want the role of women to be in our society? And perhaps the great experiment of feminism, which you alluded to here, of which the abortion issue is a pillar. It's sort of the defining issue. Perhaps the feminist experiment has failed. And in fact, it's been very destructive to society, and it's harmed women who are biologically different and are constructed to have children. And by taking women out of the childbearing business, we've had to bring in millions and millions of illegal immigrants just to keep our demographics enough to keep the economy going and perhaps compete with China or whatever. But if you look at it from the state interest, perhaps the state has an interest to rethink what are the premises underlying our current conception of American society. And perhaps they didn't have it wrong before the 1960s. Perhaps women should be raising children and men should be working.
Well, I'll respectfully disagree with that. But on the polls that I've read, about 70% of the American population does not want Roe or Casey reversed. So there's strong support to keep it.
Well, that tells us something.
Yeah, that's huge. And on the woman issue, I mean, women are entitled to participate equally in the workplace with men, and a decision as important as whether to have a child or not is a monumental one. And if the fetus is not a life, they should be able to make that decision. That's my view on it, because they do contribute great things to it. I'm frankly surprised that a woman hasn't been elected president yet.
I'm not. I mean, I think given our recent history, you can see, I was president of a women's organization for many years. Well, for 1 year, but I was vice president before that in Washington because they were doing affirmative action to bring men in. And I am a vive la différence feminist. I can tell you there is such a thing as biology. There is such a thing as genetics. And it's foolish to pretend that it's not. For all the political back and forth, men cannot bear children. All the operations, all the hormones they're going to give, they can't. Only women can bear children. Now, it may be they don't want to have American women bearing children and they want to bring in children from other countries. But the fact of the matter is, to have normal sexual reproduction, there's only one sex that can give birth to children. And the premises have to realize that careerism is not the purpose of life, because it doesn't end up with new life. I mean, now I'm sounding religious to you, but it's also what kind of society do you want to have? And if you look at a society without mothers, without homes, where the kitchen looks like a morgue, where the apartment is decorated like an office, and all the cozy I mean, I go to a synagogue now, and the women wear tefillin and yarmulkes, and it's like, what's going on? You know, it's, if they had nice scarves or dressed in a feminine way, okay, that's fine. But the idea is they're pretending that they're men, and it's not the outcome you would want in a healthy society, I think. And that's why I don't think this transgender stuff is able to be stopped unless you go to the basic premise. In other words, all those rulings, like the Gorsuch ruling and all this, once the premise is men and women are the same, which is based on a false premise biologically, everything else will follow and you'll have just collapse. But I'm just speaking for myself. So this case, yes, I agree, it's highly contentious because a lot of people sense that our society is collapsing as a result of feminism. Feminism, 70% of people support it because you can't not support it, because you can't afford to live on a single male salary. The way that it is now, you can't go back. There's no way economically anyone can survive. If somebody says, I want to be a housewife, and they're not married to Bill Gates or Steve Jobs or Elon Musk, they can't afford it. So anyway, I'm rabbiting on, but it's nice to see you're more liberal than me on this issue, because
Yeah, no, I don't think liberal, I'm libertarian on it. I think people should be judged as individuals and judged on the merits. And obviously, there's a difference between men and women biologically, but that doesn't mean that we should be forcing women to have children if they don't want to. But it also means, in my opinion at least, that if they do want to, we need to accommodate them in the workplace. And there are laws that require that. And President Biden, and I didn't support him and all of that, but nevertheless, there's some things that he does that I think make sense. Other countries support women working and raising their kids better than we do. And look at the Supreme Court itself. I mean, Justice Barrett has 7 kids. And so she's done pretty well by having a professional career and also having
what
kids.
that shows is, I'm not saying women shouldn't work ever, but I'm saying for her, that was a choice. And her choice was to have a family. And what she showed, she could have a big family and even adopt and still have a career. So the people who say it's an undue burden to have children, it'll interfere with your career, clearly have a counterexample right there on the Supreme Court.
Yeah, no, but it's still, the woman should be able to make that decision.
Without anyone else? Without the baby or the husband? Why?
We've already discussed that part of it. I do think that the husband should have be able to talk to his wife about it. At the end of the day, though, it should be the woman's decision. And I also agree that obviously we need to reproduce in order to keep society going. And so that means we obviously have to value the childbearing. And if women want to have children, we need to accommodate that in the workplace. And I think we do. As I've already said, other countries do more of it than we do. I'm not in that policy arena, so I don't know what the answer is. Do we not do it enough? Do we do it too much, et cetera, et cetera? But there are some very accomplished women, and this is the most important reason not to overrule Roe and Casey. The reliance interest of now 2 generations of women on the right to choose is overwhelming. And not everyone can be a superwoman like Justice Barrett was. And so some people need to make different choices, especially earlier in their work life. And so Roe and Casey say they get to make those choices.
All right. Well, I see you're a feminist, and I salute you for it, because it's interesting, just speaking as a male I was raised by a feminist mother, and like the French writer Michel Houellebecq, it turned me against feminism. So unfortunately, that's that sort of the irony of fate, is these feminist women who do have sons will find that they're not feminists, but or many of them are not, because it's an undue burden on the children to have mom at work all the time when the other people's mothers were home. And but in any case, it's not going to be resolved in this discussion. And I think it's fascinating. I think you pinpointed the significance and importance of this case, and I'll be looking forward to seeing how it turns out, whether Justice Thomas manages to duck the bullet, or if this blows up and becomes a major societal turning point, one way or the other, for American jurisprudence. And as you say, it turns out the key vote in this, according to your analysis, is Justice Amy Coney Barrett. So everyone will have to have their eyes on her and see what she does as a Catholic, as a mother, as a Republican, And if she then, what do they say in Washington, grows into a supporter of Roe versus Wade, even though she signed things against it. That's the little melodrama that we're watching right now. And I don't know the answer to that. You may have more information. Maybe I'll come back to you in June before the day before for a prediction. But thank you very much. I bet you were shocked that I'm anti-feminist. You can't even say it. But I was president of a ladies' organization. My mother was a feminist. She won Woman of the Year awards and flew all over and was on this and that and the other. And the day she earned more than my father, he went into a severe depression, So, I mean, there are other people involved in these dynamics. And, a yes, dear philosophy, which Jordan Peterson has said, the problem with these issues is men are constitutionally and biologically and psychologically unable to say no to a woman. And this is a serious problem facing our society today. So even when you have to say no, you just can't say no, dear. You have to say yes, dear. But on that note, which I shouldn't have the last word, I want to thank you and I admire you and I thank you for contacting me. And I'm going to put a link to your article and I guess to the hearing for people to listen to. And I look forward to coming back to you if you'll let me when this gets further. And I wish you a Merry Christmas and a Happy New Year and good health and don't let COVID bite. And maybe we can talk about the libertarian approach to COVID as well. I have to read all the books by Scott Atlas and Peter Navarro and Alex Berenson, that I've ordered on my wish list for Christmas. And then I'll come back because there's clearly autonomy issues going on in this public health case too. All right, well, thank you very much. And
All right, Larry.
all right,
Good to
see
talk to you.
you soon, I hope. Bye-bye.
All right, bye-bye.